Adequate public notice of this meeting was provided in accordance with all provisions of the Open Public Meetings Act. Practice of this board to salute the flag. Please rise and join us.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. They moved it.
Dory, please call the roll.
Dawn Herman,
Here.
Michael Josephik,
Here.
Ken Lowry,
Here.
Michael Leondi,
Here.
Bernie Reichstad,
Here.
Vice Chairman Mike Sylvester,
Here.
and Brian Zimmerman.
Here.
Thank you. And for tonight's agenda, there's just one correction. There'll be no new testimony after 9:30. Again, no new testimony after 9:30, and the meeting will adjourn at 10 p.m. sharp. And on the agenda tonight is application 689 Diamond Chip Realty. And also, we'll have a public comment at the end of the meeting, about 5 minutes to 10, maybe 10 minutes to 10, for items not on the agenda tonight. It'll have nothing to do with Diamond Chip. It'll just be if the public has questions about something else. And we'll try to allot about 10 minutes for that towards the end. And now, from the last meeting, if I recall, the public had questions of Mr. Sunderson, the architect, and not everyone got through their questions. We had one individual, I don't know if they're here or not, Beth Broderick. Now, is there any questions left over from the last meeting from the public for the architect, Mr. Sunderson from Diamond Chip Realty? No one?
And also, Mr. Warner never.
Yeah,
completed his
thank you, Mr. Collins, and I didn't want to speak out of
Oh,
turn.
no, we're
Mr.
going to get to
Chairman.
you now in
But
terms of your questions.
with your permission, before we continue the cross-examination, we did make a submission on behalf of my client, Anand Dash, and it's been responded to by applicant's counsel with respect to a very important issue before this board that we deem to be a preliminary issue that needs to be resolved by the board before the hearing on the merits of the application proceeds. And we would like an opportunity, due process, to make that contention and discuss that issue with the board to ensure that the board proceeds in the appropriate, proper legal fashion. And I suspect applicant's counsel, based upon the submission he made this afternoon at about 2:30, is going to take a different position.
So then you don't want to question Mr. Sunderson on his testimony from the last
We
meeting
do
at this
want
point,
to.
not now?
Not at this point,
Yeah.
exactly, Mr. Chairman, thank you.
All right. Tom, that's all in order then?
Yes, so if the two attorneys want to argue their position on this issue of whether there should be a preliminary hearing just on jurisdiction, they should make those oral arguments now. Mr. Warner should go first because it's his request.
Thank you, Mr. Collins. Thank you, Mr.
You're
Chairman.
welcome.
Appreciate that. Members of the board, again, my name is Steve Warner. I'm a partner with the firm of Savo, Shaw, Corsini and Warner. I represent Anand Dash, seated to my left, a Sparta resident and objector to this application. The reason we submitted is imperative that the board consider this issue is, as a board attorney, myself, most nights, we always, as Mr. Collins does as well, want to make sure that the board proceeds in the proper procedural fashion consistent with governing statutory and case law. And as I submitted to the board on May 22nd, a 3 or 4 page letter brief with the appropriate cases attached, and applicant's counsel, as I mentioned this afternoon, submitted something to Mr. Collins and copied me that took a different opinion. The issue is this. We cannot, under the municipal land use law and governing statutory and case law, have a hearing on the merits of an application with the possibility, if not probability, that the board does not have the jurisdiction to hear it and that a different standard of relief must be pursued by the applicant. Now, governing statutory and case law, including a decision by the appellate division in this particular matter, v. Sparta Zoning Board of Adjustment, govern this issue. And I'll go through it step by step, if I may. First of all, the board must first address, as a preliminary matter in a plenary hearing, abbreviated plenary hearing, the issue of jurisdiction to hear the application either as a planning board under the site plan and bulk variance standards, that planning boards are allowed to hear applications, or alternatively, if it's determined that DCR requires D-use variance relief, then, of course, as I believe all the board members know, certainly Mr. Collins will tell you, that D variances can only be heard by the Zoning Board of Adjustment, and it's a completely different standard of proof. I know our chair, pro tem for this matter, generally is the chair for the Zoning Board of Adjustment, very familiar, as no doubt others are as well, with the difference between D variance standards, particular site suitability, the Medici standard, etc. It's well-settled law that only a Board of Adjustment has statutory authority to hear a variance under 70D, a use variance or D variance. The exercise of authority by a planning board in reviewing a D variance is ultra virus, meaning beyond the board's legal power and authority. Where an applicant appears before the wrong board based on a lack of jurisdiction, any action taken by the board is a nullity. Wiped out. Never happened. And I'm citing from the governing case law, Supreme Court and Appellate Division decisions. Therefore, where a D variance is necessary, only the Board of Adjustment has jurisdiction to review the application. Second, governing case law and the law of this case dictate that DCR has the burden of proving, DCR, the applicant, has the burden of proving that the proposed use is a permitted warehouse, nothing different than that, nothing more than that. And whether that use is a conforming use is a jurisdictional issue that must be resolved by as a preliminary matter in a plenary hearing. The appellate division in the v. Township of Sparta Zoning Board of Adjustment case that was decided April 16, not that long ago, and we submitted that case and the appropriate language to you. And I quote from the appellate division judge, DCR has the burden to show the purpose listed in its application was for a permitted use in the zone as a warehouse, and the planning board would decide whether it met the ordinance. If the planning board decided the application was not for a warehouse, the zoning board would then have jurisdiction to hear any further application by DCR. While applicant claims it's ironic in the submission they made this afternoon that we rely on the court's decision in v. Sparta, it's not ironic at all. We took a different position, my client did, and asserted that it was the zoning board to make that decision. The court ruled, and the court decided that it's for this planning board to make that decision, and we're abiding by that. But the appellate division dictated to this board that DCR has the burden of establishing to you that they have a conforming use, and if they don't, the zoning board has to hear it. That's the dictate of the appellate division in this case. Whether DCR's proposal calls for a warehouse, which is a permitted use in the economic development zone, or something more different than a warehouse, is a jurisdictional issue. The answer to that inquiry determines which board has jurisdiction and what the applicable standard of proof is. And it's well-settled law, and we cited half a dozen cases. It's well-settled law that the jurisdictional issue must be resolved as a preliminary matter before the land use board hears and decides the merits of the application. Let's think about it. It's only logical. How can you hear the merits of a land use application not knowing the appropriate standard of proof that the applicant must meet to meet their burden of proof to be entitled to that relief. And for that matter, how can you do it if you might not even be the right board? You might not have the jurisdiction and might, as we showed you in many cases, including one we attached that came out just a week or so, 2 ago, the whole thing starts all over again with the appropriate board, which no one's looking to have that happen. That would be inefficient. Third, as a practical matter and is dictated by fundamental fairness, all parties in the public, as well as the board, you board members yourselves, must know whether the board has jurisdiction before it proceeds to hear the merits of the application, and you must know what the standard of proof is, what the appropriate statutory criteria is when you hear and decide the merits of the application, assuming, of course, that you have jurisdiction in the first place. And I know there was an argument made, and no doubt will continue to be made by the applicant, oh, it's going to take too long to have a targeted, specific hearing to allow the parties to make their presentations and provide you with the facts and the law so that you can make the determination that the appellate division dictated to you that you must make. Is a D-variance at issue here, or is it a conforming use? Can it stay here, or must it go to the Zoning Board of Adjustment? What is the appropriate standard of relief, the criteria that the applicant must meet, the burden of proof that the applicant must meet? As I know from the courses you take and the experience you have, as you know, the applicant and the applicant alone has the burden of proving all the elements. And as the appellate division dictated to us, the applicant also has the burden of demonstrating to you and proving to you that their use is a conforming use. The parties in the board can focus solely on the characteristics of the use proposed by Diamond Chip and its impact on whether they, in fact, have met the burden of proof that these characteristics render their project a permitted warehouse use, and not something more than that or something different than that, something that is non-conforming, and therefore would be either a conditionally permitted use, which with violations of those conditions would require D3 relief that only the zoning board can afford, or a non-permitted use, a D1 use variance that only the zoning board can provide. This issue must be heard by the, in which case only the zoning board could hear that application. And as you know, for zoning boards to grant relief, D-variance relief, it requires 5 affirmative votes out of 7 board members, not a simple majority such as is allowed for relief to be granted by a planning board, and completely different, more stringent criteria. The board can require an abbreviated testimonial and documentary evidence presentation. I suspect your board counsel will say that the issue requires what we call a plenary hearing. It's not for the board, it's not just simply a legal issue, but it requires the applicant to have an opportunity to present witnesses, to hone in on what is the use based upon the layout and configuration and site considerations at issue, as well as the operations proposed, or what they may be if they're purely spec. And we can focus on those issues and those issues alone and focus, before we focus on the merits of the application, so we don't have to do it twice. So we can make sure the right board with the right standard of proof hears the application once and once alone. We could focus on detailed site plan, we don't have to focus on issues like detailed site plan considerations, soil erosion and settlement control, drainage plans, grading plans, utility plans, lighting plans, landscaping plans, construction phasing, environmental impacts, noise, traffic, all those issues that relate to the merits of the application, as well as when we go through those issues, in the event there is an approval, we always focus as a board on conditions that could mitigate the detriments that are associated with every project. All that is the merits hearing. All that we don't want to have to do twice or three times. We don't want to do it here and then find out we have to do it at the Zoning Board of Adjustment all over again. And any record that is forwarded from here to the Zoning Board of Adjustment isn't going to have any weight. It's not going to have any value, respectfully, because no one would have been hearing the application under the appropriate standard of review, the D-variance criteria. And for that matter, this board, regrettably, under those circumstances, would have heard an application it never could have heard in the first place. We need to resolve the use issue first. It'll take a fraction of the time of a merits hearing, and then once we have a merits hearing with the appropriate board and the appropriate standard, we'll have it once and only once. You won't have to do this twice or more. And we submitted a case to you that just came out, as I mentioned, a couple of weeks ago, the Red Oaks homeowners case versus Township of Lakewood, decided in May 6th. And in that case, what I just implored you not to put yourselves and the zoning board and the borough and all the parties, including the applicant, through, which is a process of having to do it all over again. That's just what happened in Red Oaks. There, the planning board approved after multiple hearings an application, and sure enough, the trial court reversed that decision, finding that D-variance relief was required, and the appellate court, because the applicant didn't want to have to do it again, said, hey, appellate court, reversed the trial court. The trial court said, the appellate court said, no, trial court was right. And now they're left with a multi-night, multi-hearing site plan, planning board approval. That's a nullity. And they have to start all over again at the zoning board, should they so desire. We don't need to go through that. We're imploring the board to take the opportunity to do it right the first time and to take this obviously preliminary issue and let's have it resolved in the appropriate way in an abbreviated plenary hearing. Applicant can call who they wish for those targeted issues that I talked about relating to the use of the site and the buildings and the improvements. We can do the same. Members of the public can weigh in on that targeted issue, should they so desire. And we'll have a ruling so that we could start the merits hearing with the right board, with the right standard, and only do it once. The applicant's counsel submitted something to me just a couple of hours ago. They cited a case that they said I was remiss in citing. It's called the TWC Realty case. I suspect you're going to hear their view of that case. I'd respectfully ask an opportunity to respond to it because based upon what they wrote, number one, I submit they're wrong. And number two, I have a more recent case that, in my opinion, proves it. So I'd ask to have an opportunity to respond to their arguments, including the TWC case that they just sent to me a couple of hours ago. And let's do this right the first time and only have to do it one time. Thank you.
And thank you, Mr. Warner. Mr. Goen, I guess you'd like to respond?
Yeah, I'll respond. I'm going to have my partner, Adam Garcia, who's with me tonight. He's going to handle this part of the argument.
Thank you.
Good evening, members of the board, Mr. Chairman, Adam Garcia. The resolution of Mr. Dash's request is exceptionally simple, and that is it should be denied outright because there is no provision in the MLUL which authorizes the planning board to hear and determine its jurisdiction over a complete application before hearing the merits of such application. Judge Wolfson confronted that very issue in the TWC Realty case, which we provided earlier today. In TWC, the board did exactly what Mr. Dash now asked this board to do, which is, quote, "to first address and resolve the predicate issue of whether it has jurisdiction to hear the application," close quote, "before the board continues hearing the merits." In the litigation that followed the board's jurisdictional dismissal, Judge Wolfson reversed, decisively and succinctly ruling that the MLUL does not authorize such form of bifurcated hearing and instead mandates that the board grant or deny the application within the statutory period. As our Supreme Court has held, the courts, quote, "do not countenance permissive interpretation or application of the MLUL, nor is waiver or relaxation of the terms permitted." In short, the issue that Mr. Dash now brings before the board has already been considered and decisively rejected by the courts. The board must apply controlling precedent and allow the hearing of this application on the merits to continue and conclude within the statutory period.
So I'm just going to add to that because I want to talk about the Red Oaks case a little bit. That was our firm's case, so I'm pretty familiar with it. My partner, Matt Fioravanti, argued that case in front of the appellate division. So the Red Oaks case was a situation where an applicant applied to the planning board for a dormitory at a school in Lakewood. And they contended that the application was for a permitted use because the dormitory was an accessory use to the school. The planning board conducted a full hearing, and at the end of the hearing, the planning board determined, yes, we want to approve this. It's an accessory use, approved. That ultimately was appealed. It went to the appellate division, and ultimately it was reversed because the court, in reviewing the facts of the case, determined, no, it's not an accessory use. So for the objectors to rely on the Red Oaks case, it's not the same as this at all. And in fact, the planning board in that case did exactly what we're asking you to do, which is undertake your statutory mandate to hear and decide a complete application on the merits. And as Adam said, there's no provision in the MLUL that allows for a plenary hearing. Judge Wolfson in the TWC case was pretty clear that even though the MLUL has been revised several times over the last however many years, it's never been addressed, even though people have brought it up. It's never been addressed that a board should conduct a preliminary hearing. Fact of the matter is that this application is for a warehouse. It was determined to be complete. The planning board has to hear the merits of the case. The planning board will make a decision on the merits of the case. And look, if the planning board decides for whatever reason that there's a variance or there's some other issue cognizable by the zoning board of adjustment, that's our risk, right? That's the applicant's risk. But it's our burden of proof, as the appellate division said in the Dash case, to prove it to you that this planning board has jurisdiction and can grant the relief that we're asking for. It's not for us to run their case for them, to prove their case for them, go through this plenary exercise of proving whether or not we're a permitted use. We've applied for a permitted use. Our application has been deemed complete. Planning board must decide it on the merits. That's how the MLUL works. And if the board doesn't want to do that, the objectors are essentially asking you to do something that you've never done. I can guarantee you've never done it for any other planning board case that you've heard in this town, because no planning board conducts a plenary hearing to determine whether or not it's a permitted use. It's just not done. That's not what planning boards do. It's not what they're authorized to do under the MLUL. So they're asking you to do something for our case that this board has never done, that the Sparta Township Planning Board has never done. And they're asking that, and they're saying that that would be okay, that that wouldn't get appealed, depending on whatever the result of that is. If you find that the use is not permitted, that we wouldn't appeal, that if you find that the use is permitted, that they're not going to appeal that decision, and somehow they're arguing that this is going to take less time. I just find that hard to believe. And believe me, if anybody wants this thing to take more time, it's this group, right? They want this thing to take as long as possible. We are trying to prosecute this application as succinctly as possible. The way to do that is to let us put on our application, make a decision on the merits. And again, it's our risk. Whatever you find, we have to deal with it. If we don't like it, we have our appeal rights. They can make their arguments. If they don't like your decision, they have their appeal rights. Okay? But we're asking you to for the planning board to exercise its statutory authority and handle the case as the MLUL intends. Thank you.
Mr. Chairman, if I may.
Thank you, Mr. Goen, Mr. Garcia, and Mr. Warner, you want to respond now?
Thank you, Mr. Chairman.
welcome.
Respectfully, they're wrong. First of all, the Red Oaks case is to finish the description of the Red Oaks case. The reason why it was reversed and upheld on appeal, and they have to start all over again in front of the Zoning Board of Adjustment, is because they found those dorms not to be an accessory use. Those dorms were separate, independent principal use. They had two principal uses not allowed in the municipality. they have to get D variance relief. That's something we're talking about right here, right now. Same case, same situation. We're trying to avoid the do-over and having to do it twice for the municipality rather than to go through that process. And the reason it's authorized, frankly, it's done all the time. There are lots of preliminary issues. Jurisdiction, we're all aware of those. I cited half a dozen or more published decisions. There's several dozen more than that. That planning boards and zoning boards have to make those determinations all the time to make sure they have jurisdiction. And this is a jurisdictional determination. You don't have jurisdiction if a D variance is required. You don't have jurisdiction to hear the merits of the application if it is not simply a warehouse, but it is something more and/or different than a warehouse that actually is only a conditionally permitted use that violates conditions, or for that matter, might be multiple uses or a single use that is a non-permitted use. Any non-permitted use or conditionally permitted use that violates conditions requires D variance relief to the Zoning Board of Adjustment. TWC was distinguished in a decision that I provided to your council, notwithstanding the fact that I got this and was accused of not using it only a couple of hours ago. And that decision, bear with me, is the Tannenbaum decision. Tannenbaum v. Township of Wall Board of Adjustment. It's a published decision, 407 NJ Super 446, decided September 28, 2006, well after the TWC. I'm showing my age. TWA was an airline many, many years ago. TWC. And let me tell you what that case said and how it distinguished itself, and this case, from TWC. In Tannenbaum, the owners of the applicant made a subdivision application, in that case, to the planning board. The planning board made a determination that the subdivision would increase the permitted density in the zone and would require D variance relief. What we're talking about here, over which the Board of Adjustment has sole jurisdiction. They told, in fact, the applicant, you have to go to the Zoning Board of Adjustment. The applicant decided to file suit instead. But ultimately, the court ruled that an application for a variance had to be filed with the Board of Adjustment, a D5 density variance, it's one of the 6 D variances as we know, existed and the planning board had no jurisdiction. And the court went through a lengthy analysis and it addressed the TWC Realty case, because you're probably saying to yourself, I was when I saw TWC Realty, aside from all the other distinctions I made, I said, well, what did this case say about TWC? Here, and this is in the Tannenbaum case, here the planning board's expressed lack of jurisdiction is a reasonable interpretation of the statute and ordinance. There is no proof of bad faith or intentional delay on the part of the planning board. The applicant tried to play that default approval game, if you know what I mean, and say, oh, you're taking too long by addressing the issue of jurisdiction. The court slapped them back for that. And then the court went on. Unlike TWC Realty, here the Board of Adjustment was ready, willing, and able to hear the plaintiff's application. There was another board to hear the application, the correct board to hear the application, and to hear it once with the right standard of proof, so you don't have to do it twice. Plaintiffs simply, these are all quotes, plaintiffs simply disagreed with the board's decision as to which zoning requirements controlled, and they declined to go forward in that particular case. So again, the point is this. In TWC, there was no board. There was no land use board to hear. Remember, it was the zoning board, the case they cited, TWC versus Realty versus the Zoning Board of Adjustment. In that particular case, they didn't explain it. Let me explain it. Their case. Let me explain their case, TWC. In that particular case, the Zoning Board of Adjustment said, hey, wait a minute. We think this is rezoning. This rises to the level of rezoning, what you're asking the zoning board to do. And therefore, we can't do that. And they're right. No land use board, even the zoning board, can't rezone. That authority is reserved to the governing body. We know that. You zone by ordinance, legislation. You don't zone, as Mr. Collins no doubt has told you, you don't zone from the dais as a land use board, even if you're a zoning board. So that's the difference. In that case, and for that reason, TWC, the board realized and the court realized they had nowhere to go. That's not the case here. This case is the Tannenbaum case. And that's the reason Tannenbaum, the court in Tannenbaum, distinguished itself from TWC explicitly, in quotes, the way I read it. There was another board to go. As they said, the Zoning Board of Adjustment was ready, willing, and able. I added able. I'm sure they were. Ready, willing, and able to hear the case. Well, guess what? If we're successful as we expect to be on an abbreviated plenary hearing on the use issue, the Zoning Board of Adjustment in Sparta is going to be ready, willing, and I'm going to add able to hear this application under the appropriate standard of relief. And you know what? If we're wrong, so then you'll hear it under the appropriate standard of relief. But either way, it's going to be heard once. The merits of the application are going to be heard once, not twice, like in Tannenbaum, not twice, like in Red Oaks, once. Also, in TWC Realty, they spent a lot of time in that case, fresh in my mind, because I just read it, because they just sent it over. They spent a lot of time on that case talking about how the fact that it was an inherently beneficial use. An inherently beneficial use before the zoning board, and there were concerns in that particular case with the procedure because, well, what happens with all these inherently beneficial uses that are very important uses, as the court recognizes, and the MLUL recognizes for inherently beneficial uses. Those of us who do the zoning board work know you go right to the negative criteria. You satisfy the positive criteria if you have an inherently beneficial use before the zoning board on a D-variance application. Well, because that particular case involved housing for the sick and elderly, a congregate care facility, okay? Respectfully, this is not an inherently beneficial use. No one's, not even the applicant is suggesting it is. 68-acre site, 700,000 square feet of industrial buildings, 106 loading bays, more than 50 tractor-trailer parking spaces on top of the loading bay spaces, and a four-rail train spur. Nobody's saying this is a home for the sick and the elderly, okay? Nobody's saying it's an inherently beneficial use. That was a critical component of the TWC Realty case, and that's another material distinction. But I don't need that one, respectfully. The fact that Tannenbaum distinguished it because there was no board to go to in TWC, but here, like in Tannenbaum, ready, willing, and able zoning board of adjustment, if that's a determination of this planning board. When we do the first part first and the second part second. No, I have nothing further. Thank you.
Thank you, Mr. Warner. Mr. Goen, you want to respond tonight? And, excuse me, after you do, I'm going to ask our board attorney, Mr. Collins, for his comments and so forth, if that's okay, Tom?
Sure, I'll respond very briefly. So I have not read the Tannenbaum case in depth, but I just read it very quickly a minute ago. It's not inconsistent with TWC. It's not inconsistent with what we are saying. In that case, a developer applied for subdivision approval, and it turned out before the developer got to the board that there was an extra lot in the subdivision. When they determined that there was an extra lot in the subdivision, that necessarily became a density issue, which was cognizable by the zoning board because it required density variance relief. So before the planning board started, they transferred the matter to the zoning board because of purely legal issue. The subdivision application required density variance relief. In TWC, Judge Wolfson says, undoubtedly a board can resolve its own jurisdiction regarding purely legal matters. Whether or not the applicant's asking for whether or not on its face on the application, the applicant's asking for a non-permitted use, or whether or not on its face, the applicant's asking for an increase in density, purely legal matter, the board can resolve that. But jurisdictional determinations such as these, which are purely legal in nature and do not require a plenary or evidentiary hearing, are inherently proper. We agree. What we disagree with is that a plenary or an evidentiary hearing on whether or not we require D-variance relief is not proper under the MLUL. It's not authorized by the MLUL. We should not have to do it here. You will hear our application on the merits, and then you'll make a determination. Thank you.
All right, thank you.
If I
Hold your
may
dog,
very
Mr.
briefly.
Warner. Tom?
Let Mr. Warner speak one more time.
Thank you. What we heard first from the applicant was, as soon as an application gets to the planning board, after being deemed complete, the board can't consider jurisdiction any further. The board can't bring it over to the zoning board of adjustment if that's the appropriate board. The board has to hear the application in its entirety and then make the decision at the end. And now that council has read the Tannenbaum case, having given me the benefit of an hour or so to read the TWC Realty case, you see that in that case, in Tannenbaum, the planning board got the case after it was deemed complete, had quote-unquote jurisdiction given to it of the case, and then made the determination back based not just on law, on facts and law, that the zoning board of adjustment is the appropriate land use board to hear the application, the only one with the authority under the correct standard of proof for D-variance relief, in that case D5 density relief, and therefore we have to give it to them. We're giving you the opportunity, giving everyone the opportunity. I know I said it too many times already. Maybe I'll just say it one more time. To do it once and do it right, not twice, because of the possibility of doing it wrong, not without jurisdiction, ultra virus nullity.
All right, thank you, Mr. Warner. Tom,
Yes,
if you're so kind.
yes, Mr. Warner and
Oh, and I'm
Mr.
sorry, I apologize, Mr. Collins, but I do want to make sure, because we had a decision made, Brendan, this is a decision that should, under the MLUL, I would hope everyone agree, this is a decision that needs to be made as to even whether to proceed in this fashion by you, the board members. No one usurps your authority to make a decision, including the board council, respectfully.
So, Mr. Warner, and I'll ask Mr. Goen the same question. If the board were to hold a preliminary or plenary hearing on whether the use is a warehouse or some use that requires a D-variance, such as a trucking terminal, I think is Mr. Dash's argument that it somehow is a trucking terminal, or at least in part a trucking terminal, which you didn't really address in your argument, but I might ask you to address further. But if the board were to decide to have such a hearing first, what witness or witnesses would you present, and what do you proffer the board as what those witnesses would prove to the board? Try to summarize in short paragraphs or two, I don't care how long, take your time, but summarize who your witnesses are and what you offer the board that you will prove through those witnesses with some degree of specificity, the names and their testimony, expected testimony, kind of like an opening statement. I'm going to ask Mr. Goen to do the same thing. If the board holds a hearing that's preliminary as to jurisdiction and the question of fact and law, which is what the appellate division agreed with the planning board about, that this is a question of fact and law. What are your witnesses? What are they going to prove without, you don't have to give every detail, but if you would give enough detail for us to understand that proof.
Well, I think, Mr. Collins, if the board were to make.
I
Oh,
want
sorry.
Mr. Warner to go first.
I'm sorry.
Okay. If Mr. Collins would like me to go first, I will go first,
Yes, he
Mr. Chairman.
should, because he's asking the board to have a hearing that is not on all of the merits, it's just on some of the merits, I'd say, that the way I read what you're writing and what you're arguing. So proffer what you would say in this, present through witnesses in your hearing?
The first thing I would open with is that I don't open. The applicant has the burden of proof to prove, as the appellate division has said and as Mr. Collins has just reiterated, that their use is a conforming use. So the applicant would go first.
I'm not talking about what
no,
the
I'm gonna
order is of the application. I'm talking about, you've asked for the board to have a hearing. In that hearing, who is your witness? What will they say?
I'm gonna list how I anticipate it happening. Absolutely. I just wanted to make clear where the burden of proof lies and where the order would be, so there's no
We
confusion.
totally agree. I think everyone agrees that the burden of proof in an application for development is on the applicant. So go further now onto what you will prove in your hearing on the facts and law as to whether it's a warehouse or a trucking terminal or some other D-variance requirement.
Certainly, I would, given that the applicant has the burden of proof and would go first, I would first cross-examine applicant's witnesses. Assuming applicants put forth their operations witness, Mr. Ford, their engineer, Mr. Deegan, if I'm pronouncing his name correctly, their traffic engineer, whose name I had in front of me a moment ago, and my apologies for forgetting his name, if it's the same traffic engineer who testified 2 years ago.
No one testified.
Oh, I'm sorry, who was
No
listed on the
traffic engineer
report.
testified 2 years ago.
That's right, my
So-
apologies.
And by the way, don't, maybe focus on what you are going to present so that Mr. Gouen can then tell us who he will present
Certainly.
based upon your witnesses.
Based on the cross-examinations, I would see what exactly the operations are, the site characteristics, in anticipation of a lot of its spec we don't know, which requires the board to assume, in essence, that it could be the quote-unquote worst-case scenario. And then when the applicant rests, because it's the applicant's burden of proof, then I would present likely at least 2 witnesses. One, a traffic engineer, particularly with respect to parking, but also traffic, because that relates to the type of use or uses that this may really be or become once, if and when it's approved by any board. And then,
Now, Steve, we're just talking about what you're going to present in the preliminary hearing on jurisdiction.
that's what I'm presenting. I'm presenting a traffic engineer and a planner,
But you
and I
just-
may have someone from the logistics industry as well.
But you just said, okay, go ahead. So a traffic
And
engineer,
A traffic engineer, someone from the logistics industry, and
by
a planner,
someone, like an expert?
like a fact and expert.
What do you mean by a fact and expert? Like,
Well,
is
someone
there
who
is there an expertise that you're thinking of?
could distinguish based on not only site considerations, but operations as testified to by that point, the applicant's witnesses, as to whether indeed this is a conforming warehouse use, whether it may be something else, whether it may be a combination of things like a warehouse and a truck terminal, and hence be 2 principal uses which are prohibited under the ordinance in Sparta and require D1 use variance relief from the zoning board of adjustment,
So, and then also.
and also a
Mr.
single.
Steck, right?
I'm sorry?
Mr. Steck?
Well, that's
We've been
the
told in the
planner.
past that Mr. Steck.
Yeah, the planner would be Mr. Steck, correct?
Mr. Peter Steck,
Right,
professional planner.
yes. We have had attorney-client privilege consultations with the other 2. I am not at liberty yet to name them, nor respectfully should I have to, before the applicant has even begun the use variance, the use hearing.
Yeah, we're not hearing a use variance at the planning board.
No,
Assure you-
the use
assure
hearing.
you of that. So-
Yeah, to ensure it's the right board, the conforming use hearing.
So
The-
so
the-
you
the,
envision three witnesses and.
Three
how about-
witnesses.
How about the plaintiff? The applicant.
The
I'm sorry,
applicant.
the objector, Mr. Dash. Does he intend to testify?
He may as a fact witness if necessary. It depends on how the testimony comes out from the applicant. I'm not going to limit myself. I suspect they're not going to limit themselves, and they're going to go first. So,
And you said that you would envision that members of the public could then also both cross-examine, I think you said, and testify as to this issue, the jurisdictional issue. So that's what you envision, like a full participation by anybody who's interested in the plenary hearing, as
To the
long as
extent-
they focus on jurisdiction.
to the extent it's a plenary hearing, I don't know that we could, nor respectfully, I don't believe that we should exclude anyone.
Okay. So now turning to Mr. Guin, you've heard the plaintiff, the objector's proffer of what they would proffer in a plenary hearing on jurisdiction. If you were to be confronted with a ruling by the board that there will be a preliminary or plenary hearing on jurisdiction as to whether it's a warehouse or a D-variance use plus a warehouse or just a D-variance use, who would you present to prove that it is a warehouse and not a D-variance use?
Well, I would say, first of all, no offense to anybody on the board, if the board were to make that determination, the first thing we would do is appeal that determination. So, I mean, that would obviously be our first move. If
Not
we
so
were-
sure that you would, but let's not get into threats here because
not-
it's totally,
it's not a threat.
totally unnecessary.
It's not a threat.
I asked you a question about this hearing at this board that we've been working on for 2 years, and this is a seminal issue in the case, whether it is a warehouse or a trucking terminal or a warehouse with a trucking terminal, and you need to address it because the objector has raised the issue and asked the board to have a plenary hearing. So what are you going to present as witnesses, and what would you proffer that they would argue or state or opine as to why it is not a trucking terminal or why it is not a warehouse plus a trucking terminal?
Well, Mr. Collins, with all due respect, we would present our case. I mean, we would present our architect, which we already have. We'd present our engineer, present our traffic engineer, our planner. I mean, we'd present our entire case, which I think is why I'm making the point that this is not going to save any time. We're going to present our entire case in this plenary hearing, and, you know, the board's going to have to make a decision, and then we're going to have to go back and do it again. So,
And Mr. Goldwyn, excuse me, Tom, would you have any witnesses too that would discuss the potential, the rail yard and rail siding? Because besides being a warehouse, potentially trucking terminal, et cetera, it seems to be off the page about the rail siding and rail yard. That's another whole issue.
okay.
So you would cover that too with witnesses?
Yeah.
Thank you.
So your point, Mr. Goen, is even if it was a plenary hearing, you would basically present all of your witnesses and all of the evidence that you would present even if it wasn't a plenary hearing.
I'm not sure how we get to resolving the issue that's being raised without presenting our entire case, so.
That's your argument, okay.
Mr. Collins, may I just reply to that very briefly?
Yes, please.
Because, and I hesitate to say this, but I can't help but feel as if it almost sounds like an effort to sabotage and to say that we're going to do more than we need to do so that you decide we don't have to do it in the right order. We should do it all together in a mishmash. And at the end of the line, find out whether we were in front of the right board with the right standard of review or the wrong board with the, and have to start all over again. I would hope that the applicant, by making that presentation to you, wasn't trying to sabotage and get the outcome that they might want for the wrong reason, because it can be limited. And I respectfully laid it out in my May 22 letter. I went through not only how it can be abbreviated with the appropriate site consideration topics and witnesses, engineer traffic operations. They want a planner, they should have a planner. We'll have one too, as mentioned, and other witnesses who will speak to the use issue. And I went through detailed site plan considerations, not just the configurations and the layouts and the operations of what's happening. soil erosion and sediment control, drainage, grading, utility, lighting, landscaping, phasing of constructions, environmental impacts, noise, traffic, architectural features, visual impacts, all very important things for every land use board to consider when they're deciding the merits of the application. Respectfully, don't make much, if any, difference to whether it's a conforming use or not.
Mr. Warner.
And all the
could you just-
mitigating conditions that would have to be addressed with that to mitigate all those impacts don't have to be dealt with in the abbreviated plenary hearing that we're talking about. Thank you.
Mr. Warner, could you please identify what Mr. Steck's opinions will be for purposes of the proffer, for whether to have a jurisdictional hearing? And then I'm going to ask Mr. Goen to address what he would present to rebut what Mr. Steck is going to say. I think you know the answers to these, so I think this is a good time to proffer what you're going to offer to prove through the witness. And then the applicant will be faced with what his confrontation is going to be for that witness. So please go ahead.
And I will do so. I will
Please do
do
that.
so, Mr. Collins, but it's incumbent upon me, I'm constrained to say at the front end, again, that two things. One, I can't be bound to this. We haven't even heard the applicant begin to try to make the case for a conforming use yet, so that I'm supposed to now explain who and how and what and why we're going to be able to combat that, and it's the applicant's burden of proof. But with all that said, after the applicant attempts to make their case, it's not beyond a reasonable doubt, it's not a criminal case, we're not going to rest without calling any witnesses. We're going to have witnesses after we cross-examine, I'm sure. And those witnesses, as I mentioned, would be a traffic engineer, a logistics, a fact and expert witness, and Mr. Steck, the planner. And what we anticipate Mr. Steck's planning conclusions to be are one or more of the following. This is either a warehouse, two principal uses, one being a warehouse use and one being a truck terminal, and two principal uses under the Sparta ordinance are not allowed on one lot, even if they were both permitted. The truck terminal, as I think by now we all know, is admittedly a D variance in and of itself, D3, because it's a conditionally permitted use, which of course means it has to meet all the conditions, and we know several of them are not met. No one's arguing or will argue against that. Or it's a single it's a single integrated use, and we could call it a multimodal integrated logistics park, a freight village. There's different names for these things. But at the end of the day, even that single integrated use is something more than a warehouse and something more than one permitted use, one principal permitted use. I don't necessarily anticipate that the conclusion will also be, or will instead be, it's a truck terminal and nothing more. But I'm not, that's a proffer. These are all proffers, and I think the board understands what we lawyers like to use these words. Proffers mean, at least it's not Latin. By proffer, it simply means what we anticipate. We're not held to it. Don't hold it against us, but that's what I anticipate. And again, that's what I anticipate representing the party that doesn't have to prove respectfully a darn thing and goes last after the applicant who has to prove everything goes first.
Thank you, Mr. Warner. Mr. Goen, if you were to be confronted with a hearing with a planner like Mr. Steck and those two other witnesses, what would you offer to just address those particular
So I think we'd offer much the same testimony. Again, we'd be offering basically the same testimony that we plan to present to the board anyway in connection with our application. We've already heard from our architect who testified about the design of the building, so we'd be presenting that testimony again, I suppose. We'd hear from our engineer who's going to talk about the design of the site. We would hear from our professional planner. And I think the board wants to hear about some measure of operational testimony, like the chairman mentioned. So we'd present that testimony also, but at the end of the day, all that testimony would be driven towards a conclusion that this is a project that meets the definition of warehouse, which is what we've applied for.
Thank you, gentlemen.
And
So-
if I may, Mr. Collins, I suspect while some of those are the same witnesses, based upon the discussion we had, it should be clear to everyone, the magnitude of the testimony is a fraction of what it would otherwise be on the merits with all those other issues I was laying out ad nauseum earlier.
Well, that's your position, but Mr. Goins' position is he would present all of his witnesses and all of the information, even if it was a plenary hearing. So,
I would hope he
and
wouldn't.
I'm not so
sabotage
sure,
things.
I doubt that we could actually prevent that, even if we say focus. So I'll just help the board understand your role here. So in my opinion, it's an issue of fact and law, and that has been the issue in this case since the beginning. The planning board so found it to be an issue of fact and law, which means you need witnesses. You can't proceed just on the legal issue. The law division agreed with the planning board on that decision of the planning board, and the health division agreed with the law division and the planning board and the zoning board actually on that issue, that it is something for the planning board to determine during the hearing based upon fact and law. No, nothing in the prior opinions directly addressed whether the board could have a plenary or preliminary hearing on whether it is a warehouse or something like a warehouse plus a trucking terminal or just a trucking terminal or something that is not a permitted use. But in every planning board case, the board only approves something if it is a permitted use and if it conforms with all of the ordinances, not just whether it happens to be called a warehouse, but whether it actually conforms with all of the standards for any use. That's true in every planning board case, because the planning board has no jurisdiction over use variances or D variance under section 70D. Anything that has a D variance is entirely within the jurisdiction of the zoning board. The TWC case cited by the applicant is not particularly on point because it, first of all, it is not a binding decision on Sussex, the Sussex vicinage. It is a decision by a law division judge in Middlesex County, which is not technically binding. On the other hand, it is written well and it focuses on what is the issue in that case, which is actually a very different jurisdictional issue. And that distinction is significant because that case is a zoning board case. And what the zoning board ruled is that it did not have jurisdiction because it was, the use was effectively a rezoning, and there was no way for the applicant to proceed because the zoning board refused to hear the case. The court said, no, it has to hear a use variance, and it has to hear the application on that use variance. This is not, we are not a zoning board. We are not here to, on a D variance application. And that is, so that case is distinguishable on that grounds alone. But the Lakewood case is also distinguishable because the dormitory was not listed in the ordinance. In this case, the warehouse use is listed in the ordinance. And the trucking terminal is listed only as a conditional use in the ordinance, and the conditions are not met on this property, at least in one part, because it is not within 500 feet of the state highway. So we know that a trucking terminal is not possible at this property by this board, and that any trucking terminal would have to go to the zoning board for a D3 variance at a minimum, and under the new ordinance, for a use variance because trucking terminals are not permitted under the newest ordinance. That being said, in my opinion, the board has jurisdiction to determine in this hearing tonight, or even in a future hearing, whether you want more evidence or want to have a focus of the testimony and a plenary hearing on the jurisdictional issue of whether the use is a warehouse or a trucking terminal, or a warehouse with a trucking terminal, or some other use that is not permitted in the ordinance. I would say to you, I am not confident that that will be a short hearing. I actually think it may be extremely long. And you will not be able to totally foreclose that because the applicant has the opportunity to present whatever witnesses they want to present on that subject. And so do the objectors, and so do the people in the public. And so questions and testimony will have to be offered to everyone, even if it's split between a preliminary hearing and a future merits hearing. And that might mean it's twice as long, but it doesn't necessarily mean that. And so the parties will argue their arguments, but witnesses have to be presented no matter what to address this subject. And it's up to the board to help decide how to structure that. I'm satisfied that the board has discretion on this. I also am satisfied that even if you started a hearing and you started hearing the whole case and you heard every single witness, you could still reach conclusions at the end of that, that something is not a permitted use. And that is a consequence of applicants pushing their cases, and that can be a result. And when that happens, there's not a lot of case law on the subject, but there's a commentary by the treatise that Bill Cox wrote, in which he personally wrote, in which the current draftspeople seem to support, which is that a case where the planning board finds it lacks jurisdictions after starting the case, that record can be administratively transferred to the zoning board, and the zoning board can hear the D variance and decide whether to consider the record previously made at the planning board at the zoning board. So it is not all for naught. It is not a total waste. It's at that point up to the zoning board whether and to what extent it wants to accept the testimony and record presented at the zoning board. There will be no duty here, though, for either the applicant or the objectors to prove a D variance. We will not be deciding a D variance here at the planning board. So there will be no duty for the applicant to have a different burden of proof because there is no jurisdiction to hear D variance cases here. The point I'm making is, either way, at some point in this case, possibly at the end, the planning board will make a ruling on this subject. If you don't make it in the first part in a plenary hearing, you're going to be making it at the end of the case. So I think the way to approach this now would be for the 5 people who are eligible, which is the 4 regular planning board members and Mr. Laurie, the replacement for a recusal, to perhaps consider a motion whether to have a preliminary hearing on jurisdiction or whether not to have it. And I could help you craft that motion if you want me to help you, or if you want to talk about it, you could talk about it as well. You could also deliberate about it a
Do
little
we
bit.
have to open it to the public to question the attorneys? or
No,
at
no,
this
the
point?
attorneys are not witnesses, and they're sworn to be officers of the court, and their representations are considered to be truthful, and I'm sure they are. So please,
Some comments from the board members that can vote?
and everybody can comment,
Yeah,
but only those 5 can vote.
5, but everyone can comment on what Tom just said in terms of having a preliminary hearing on jurisdiction of this application. So we can start down there with Brian, Mike.
So if we move this to the zoning board.
Let's, this is just a preliminary hearing
Okay,
on
sorry,
jurisdiction.
Talking to their microphones.
Yeah, sorry, Mike.
I'm going to withhold from comment.
Yeah, Brian, the only issue now would be whether you're going to break the hearing into parts, where the first part would be the applicant trying to prove to you anything they want to prove as to why it's conforming with the ordinance as to a warehouse, and the interested party, Mr. Dash, and his attorney and witnesses presenting testimony on why it is not a permitted use warehouse, but is something like a trucking terminal or a combination of trucking terminal and warehouse, or some permitted, some use that's not permitted.
Okay, I'm gonna hold my comments for now.
Mike?
And you don't have to make comments, by the
Yeah,
way.
you don't have to comment.
You know, no one has to comment.
All right, I have some questions. And I think I know the answer, but I'm going to put it out there anyway. The state recognizes planning board, zoning boards, and a joint board. And this is a very unique circumstance. I know Sparta is planning board and zoning board, but here we are sitting with a mixture of zoning and planning people. Is there a way through ordinance or some other way that we could be treated as a joint board for purposes of this application only, since everything else is for this application
Good
only?
question, Joan, but the answer is no.
That's what I thought, but I wanted to ask.
But it's very fascinating because we do have members of the zoning board here with us, and so their participation, as instead of recused members, in this case, Ken is the recused replacement, the others are potentially here, and I'll be talking more about that later tonight, but we may not be able to rely on the two Mikes, Mike Josephik and Mike Leondi, because the statute does say to achieve a quorum of 5. But the interesting nuance is that if the case is transferred to the zoning board at some point in time, or if it's denied and they'll go to the zoning board would probably have similar issues about disqualifications, and so the Ken and the two Mikes would probably be eligible at the zoning board, and they have to have a quorum of 4, but to do D-variances, they have to have a quorum of 5. They have to have a group of 5. So it's possible that the case will be there, but it's also possible that it will not, and that's something that this board will be deciding at some point in the case, either after a plenary hearing or preliminary hearing, or at the end of the case. So I know it's complex. I know it takes a lot of consideration of different attorneys' arguments. I don't think you're going to see the case get that much shorter if you have a plenary hearing, at least not the way I'm hearing the attorneys, but that's never the reason to decide things, the speed. The reason to decide things is based upon the facts and law of everything that comes before the board, and only that comes before the board in the hearing. And we have only gotten to the first witness, and we haven't even finished his cross. So,
Thank you, Tom. And again, it's just, this potential motion is just for having a preliminary hearing on jurisdiction of this application, and both sides would present their case and so forth, but it would still be here before the planning board.
Okay, I have another question. You're asking us if we should have a preliminary hearing for a use variance for warehouse versus?
No, Joan. This is just a preliminary hearing on the jurisdiction of this application, nothing to do with variances, anything at this point. They're going to have to present their case, and after all the witnesses, like Tom has been saying, then we'll have an idea what's the next step after that. But right at this point, there's nothing to do with any variances and et cetera.
Okay, so we could hear it to a certain point, and then at that point, we can decide to transfer it?
that could
Or keep it.
Potentially,
be a
Joan.
result,
Yeah.
right?
Okay.
The question is whether to break the hearing in parts and to have a preliminary hearing as to the facts and law on the jurisdictional question of whether it is a warehouse or whether it is not, it is a warehouse with a trucking terminal, or a trucking terminal by itself, or a use that is not permitted in the zone. That's what Mr. Warner says he wants to prove in the hearing. By the way, if you say, let's not break it apart, let's have a regular hearing, all of this will still be evidentiary in the regular hearing, because in every case, the applicant has to prove that they comply with the ordinance or obtain any C variances and site plan exceptions that they require, and they must prove that they are permitted use in conforming with the ordinances. Similarly, the objector will have the right in the hearing, whether it's preliminary hearing or a full hearing, to present all of their evidence, and so with the public, about why they contend that it doesn't conform with the ordinances, and why they contend it should go to the zoning board, if at all. And so that's always going to be an issue, even in a longer or non-split hearing.
And Joan, that's what a preliminary hearing on this jurisdiction will cover all what Tom just said.
Okay, I would agree with that.
Mike and Ernie, you have any comments, et cetera?
Yeah, just Tom, just for clarification, you said the court already decided that the application should be heard by planning board, correct?
That the application,
Oh, yeah.
including the issue of whether it's
I'm loud enough.
including the issue of whether it's a
All right,
warehouse.
I'll restate that. Thank you. So,
I know the question, Mike.
Go ahead.
The answer is no, it's more than that. They can also present proofs on why it's not a warehouse, even in this hearing. Okay? That's what you're,
and my other question, I think I heard it correctly, is regardless if we did a preliminary or proceeded, that the issue of time's kind of been rebutted because it's going to go through its entire process, whether we bifurcate it in the front end or back end, the
yes,
issue of time's kind of been rebutted here, correct?
yeah, I wouldn't use the word bifurcated because that's a special term of art from the statute, but in terms of if it is a split hearing or a separated hearing, based upon what Mr. Gouen said he would present, and even based upon the three witnesses that Mr. Warner said he would present, and the fact that, in my opinion, everyone from the public would be entitled to testify in both hearings, it will not necessarily be short. I don't
No
think
further
I don't think anything about this case is going to be short. So,
Thank you.
Tom, just one last question, was speaking about the warehouse and warehouse, trucking terminal, warehouse. What about the rail siding and rail yard part of this whole situation too? Because I think that's important.
yes, well, if he were to, that might be a piece of evidence that is important to both the applicant and the objector, Mr. Dash, because he raised that in his prior objections. So that will probably be an issue in the plenary hearing or preliminary hearing, if there was one. But that's up to those parties, up to Mr. Gouen and Mr. Warner to present what they want to present on that subject. And frankly, you might inquire about anything that helps you make that determination of whether it's a warehouse or a trucking terminal or a warehouse plus a trucking terminal or a use that's not permitted in the zone, because that's your role, is to make sure that something is a permitted use. That being said, so I'll offer a motion that you could consider. If you deny this motion, all that means is that we're going to continue with the full hearings, and these issues will still be issues in the full hearings. If you grant the motion, then we'll be breaking it into two, and we'll be trying to have the parties focus on the jurisdictional issue. But if we go, that it really will be, even if you don't split it in two, these issues will be part of the case.
Tom,
Okay.
one quick question. When you, the hearing, if we were to grant the hearing, is that considered testimony
Yes,
on the
yes,
case? So
yes.
it doesn't have to be redone?
No, I even think, and there's no case law on the subject from what I know, but I've had my own experiences that this testimony here could be transferred to the zoning board, and the zoning board could decide that it's keeping the record. Then the parties can supplement that record at the zoning board if that's what happens. So this is called an administrative transfer. Mr. Warner doesn't agree with me. I've never addressed it to Mr. Gouen, but in my opinion, a zoning board has jurisdiction to accept a transfer of a record from a planning board where the planning board finds that it's not a permitted use. And by the way, these kinds of issues can come up in every single planning board case because every single planning board case is for permitted uses. And objectors can always argue that some permitted use, allegedly permitted use, is not a permitted use, that the use is not meeting the standard of the zoning ordinance. So it's not unusual to have a jurisdictional debate in the hearings before a planning board. But in these kinds of cases, you do have to hear facts, you have to hear testimony. You can't just make it solely upon law, whereas there are cases where it is a matter of law. This has been determined to be a matter of a mixed issue of fact and law, determined so by the planning board, determined so by the Judge Minkowitz, determined so by the appellate division. And so it's back to you, and you're going to be making that determination of fact and law.
Tom, do you want to make the motion on the
Yes.
potential
So
hearing?
it's a motion to decide, the motion is for the board, just the 5 members, to confirm that you want the parties to focus a preliminary or plenary hearing on the jurisdictional issues to be followed with a full additional hearing beyond the jurisdictional issues if the board determines after the first part that you're finding jurisdiction. So it's a motion to have a plenary hearing. Is there such a motion?
This second too, Tom?
We need a motion and a second. Did Joan say motion?
motion.
Motion by Joan. And is there a second?
Second, please.
Second that.
Second by Mr. Zimmerman.
Or you could please call the roll.
Joan Furman,
Yes.
Ken Laurie,
Yes.
Ernie Reichstad,
Yes.
Mike Sylvester,
No.
Brian Zimmerman.
Yes.
Okay, so we're going to be going with the plenary or preliminary hearing first, and it should be Mr. Goen who proceeds. And for now, Mr. Goen, I'm not going to limit your presentations. I actually think since we had you presented an architect, you might as well finish the architect through Mr. Warner, who has not cross-examined him yet, and then you can decide who you want to present next. So that prior meeting will be part of the hearing.
Yeah, Mr. Collins, I'm not sure that we want to proceed in that fashion. I think if we're going to do a preliminary hearing, we should prepare for a preliminary hearing and
Well, that's your call.
put our proofs on. I'm not sure that doing cross-examination now really serves any purpose. So, I think we should probably, if that's the way we're going to go, we have to prepare for a new hearing.
Agreed.
Okay, but let's set a date because we're having some trouble with scheduling.
Was it the July 1st or the 9th, Tom? I remember.
It turns out that Mike is available on July 9th. And so we do think, but can we get the
We haven't
location?
confirmed that yet.
So
That's a Tuesday, correct?
that's Tuesday. Does that work for you, Mr. Warner? So here, let me just explain the problem. July 3rd would have been a regular planning board meeting, but that was canceled at the beginning of the year as is customary because that is the 4th of July weekend and the day before the 4th of July. It would be quite difficult for the board to get a quorum and for professionals and the public to participate in the applicant, et cetera, on the night before the 4th of July. So there is no scheduled planning board meeting. Also, this room, strangely enough, is incredibly booked for many different public functions, none to be criticized, all great public entities, the court, the all the different agencies and the council. So Jory and I have found it extremely difficult to find a meeting space. She is going to work on trying to get the Mohawk Avenue School, which is the place where the Board of Education holds public meetings, to be rentable by us or the applicants at the applicant's cost. And one night, the only one night that seems to work for most of our professionals and all of the, at least the five key people who are the 4 planning board members and Ken Laurie, the replacement to the recused person, that they're all available, we think. But we don't know that we have the Mohawk Avenue School. If it works for you two gentlemen, it's you, Mr. Dash and Mr. Warner and Mr. Guin and whoever he would likely present, we could try to carry to that date certain at the Mohawk Avenue School and cancel if we cannot get the school. Because frankly, we don't have, this meeting room I don't believe is available on July 9th. I think it's a council meeting, but I'm not sure.
Tom, what was the date?
July 9th. It's a Tuesday. It's a little different. We were thinking 7 p.m. at the Mohawk Avenue School, but we have not yet arranged for that with the superintendent of schools. I believe there'll be a charge. And obviously, if the applicant is paying for it, they would have to know what that charge is. And Mr. Goen has indicated that he's willing to have the applicant pay the cost, but he doesn't know the cost yet. So, which it's usually, I think it has to do with having a licensed boiler operator in the school at the time that a meeting takes place. Whatever they have to do at schools. Mr. Warner, Mr. Goen and Mr. Warner, those nights, does that night work for you? We're trying to replace a first Wednesday because that's when the Diamond Chip Board is most likely to be able to get together.
Yeah, that works for me. Yeah, so the July 9th is fine.
Mr. Warner?
I do have a conflict. I do have co-counsel, as you're aware, and we are trying now.
Checking out.
Apparently, he doesn't check the text every second. I think he's conflicted out tonight, frankly, so it might be part of the reason, but I don't,
Okay.
I mean, I don't want to, we don't want to hold things up any further. We want to move efficiently. So it may be that we can agree to the 9th and between my co-counsel and myself, find a way. At least
Yeah, well,
I know-
cooperation is expected, and
yeah.
we would cooperate, but I have to say, Dory and I are we're challenged. We were amazed at how booked this meeting room is. We never quite were aware of that, and we don't think it would be good we wish we could be in this meeting room, because it is the best place.
I know it's important for the board. I know how the board attorney feels in trying to do scheduling, to at least have a date certain to carry.
Right.
As a courtesy to the applicant without further notice, and to hope then that one of us can be there that night. And I'll work on my schedule if Mr. Simon can't be there. We don't know yet.
Okay. Would it help to have a 5-minute break and to see if you can call him, or do you?
Yeah, I didn't want to call
try?
him
I don't want you
sitting
to
here, sure.
do it if it's not even worth it, but.
Yeah, I'm
When,
happy to
Mr. Chairman,
Yeah, the
I think it would
hearing's in-
make sense to take a 5-minute break.
recess for
I know
5
people
minutes.
don't really need a break, but Mr. Warner does, and that makes sense. So
It will take a 5-minute recess and be back in hearing at 8:30. Thank you. You ready, Dory? Yeah. Okay. So, what about the dates, Mr. Goen?
Well, we're okay with July 9th, so.
Yes, thank you, Mr. Goen, and Mr. Warner has informed me. Why don't you describe, Steve, what you would propose?
Sure. Thank you, Mr. Chairman.
Excuse me, can everyone speak into the microphones directly? A lot of the people have been complaining they can't hear us, et cetera. All right, thank you.
Certainly.
Thank you.
As I had mentioned to Mr. Collins, we just found out that my co-counsel has a conflict that night, as do I. But as I said before, we want to be as accommodating as we can be. So I am going to work to try to resolve that conflict. And very candidly, although it's not that candid because I'm saying it in the microphone in a public meeting, I'm going to work on my co-counsel to also try to resolve that conflict that he has, because I don't know the specifics of that. He's on his feet right now. He just texted back. And I'm hopeful that at least, well, that one of us can make it here that evening. And I want to accommodate having a date certain for the board and everyone else to be able to carry the matter without further notice. So that's the best I can offer at this point.
Mr. Goen,
I would respectfully.
I think it's worth trying to do that. Is that okay with Mr. Goen?
Yeah, that's fine. I mean, that's fine if for whatever reason, Tom, if we got to reschedule it, we'll talk about it. If we have to renotice, we'll have to renotice.
And
Tom, what about the 10th?
Everybody should know that we don't yet have confirmation with the Board of Education or the superintendent, and so their schedule may not allow.
What about the 10th? If it can't be the 9th, why don't we just slide it until we find a date?
Because we have.
Logistics
we
issue?
We have gone through a laborious process to get 5 members and the professionals, and that date was not one of those dates. So,
Wednesday, second Wednesday?
second Wednesday is not good for at least.
No, that's a
at least
zoning
couple
board-
of
zoning board
professionals, yeah.
meeting.
So it's also the zoning board. You can't be in 2 places at once, Mike.
Can't be in two
But,
places, Mike, you tried anyway.
So we will, well, let's just do this. So I just confirmed that we don't actually know that the Mohawk Avenue School will be available. If it is not, Dory will inform the attorneys and we'll post it on the website that could not have a meeting on July 9th. But if it does work, there will not be an additional notice. The hearing will be carried to 7 p.m. on July 9th at the Mohawk Avenue School. There is a chance that will be canceled, and if it is, we'll give as much notice as we can. If there's a different rescheduled date, that rescheduled date will have to be noticed by the applicant in the newspaper and the mailings.
Tom, could you also try the high school?
We could try. The problem is, I think, one of audiovisual and recording equipment, and I believe that is stationed at the Mohawk Avenue. I don't understand how it works, but I think they have it. They can set it up. No, Jen knows something. I don't know. That's where they don't have the recording there? Oh, they do have it? Okay.
They bring it.
Why are they meeting? Oh, all right, so Dory will, and Mr. Zepp, the manager, will coordinate with the superintendent. I don't think, we should say that we're doing it at the Mohawk Avenue School, though, for tonight, because that is the carrying of the notice. We have to say a place, and they are meeting, I believe the Board of Education meets in the Mohawk Avenue School on July 18th, if I'm not mistaken. That ring a bell? Yeah, that particular week is the third week. So for now, that's what we're doing. We're carrying it without a date certain, without additional notices, I'm sorry, to a date certain of July 9th at 7 p.m. at the Mohawk Avenue School.
Thank you, Tom.
We're adjourning. Oh,
Okay,
you're
Tom,
going to open for 5 minutes about non-DCR things.
Yeah.
Not
Real
sure that.
quick, Tom, the meeting after that is still August 7th? Is that the next?
August
scheduled?
7th, we're aiming for here at the municipal building.
And Mr. Scott, if I may, in fairness, since applicant will be opening, can we be afforded the opportunity to know which witnesses will be presented so that we can properly prepare cross-examination on this targeted issue?
Yeah, well, we'll submit something, I think, to everybody before the hearing. Can we, well, I mean, generally we would do it 10 days before, but
That's fine.
Thank you.
Sounded like everybody though, Steve.
I mean, I think you
I have
can,
to admit.
you can kind of figure. It's going to start a lot, it's going to start a lot like the first hearing did.
Everything set with the attorneys? Now to the public, anyone in
you.
the public have any questions or comments on items that are not on the agenda tonight, not relating to Diamond Chip? Excuse me? No. Not at this time. Tom, could you explain?
Wait, because it's not a,
Yeah.
this was oral argument by two attorneys, not open to the public.
Yeah.
Now the hearing is being rescheduled and will be the focus of a jurisdictional hearing as explained this evening. You will have the right to testify and cross-examine people, cross-examine witnesses and testify in that hearing as to those jurisdictional issues.
So I just wanted to clarify, the Board of Ed meeting for July is
Jenny, can you give your?
Yeah, now you're
Jennifer
talking.
Derrick's Tap into Sparta. The July meeting for the Board of Ed is the 16th, not the 18th. Just to clarify
At
that.
the Mohawk Avenue School though, right?
At the Mohawk Avenue School, if you're requesting this, any space, that request probably needs to go again because they were told somehow that to disregard the original request.
Yes, Dory and Jim know that. And
Okay.
they are going to go back.
Thank you.
We didn't think we had the 9th available, but it turns out all 5 of the Diamond Chip members are available July 9th. And the professionals mostly.
Any other questions from the public on items that are not on the agenda tonight?
And by the way, Mr. Zepp texted Dory that he's reached out to the superintendent or the Board of Ed about July 9th, and they'll be working on that. But that doesn't mean it's set, it just means that Mr. Zepp is working on it.
Okay, and if no other questions or comments, et cetera, we will adjourn the meeting. Do I have a motion?
Motion to adjourn.
Second? All in favor? Thank you.
Good night, guys.
Good night.